Okay, good morning. I'd like to call this meeting to order. The time is now 9:08, and today is Thursday, March 22nd, 2018, and this is day one of the Physical Therapy Board of California's board meeting. We are meeting in the Department of Consumer Affairs hearing room located at 2005 Evergreen Street in Sacramento. Could we please have roll call?
Alicia Rabina Amen.
Here.
TJ Watkins.
Yeah.
Deborah Alvizo.
Here.
Jesus Dominguez.
Here.
Daniel Drummer.
Present.
Katarina Ellaby.
Present.
Tanya McMillan.
Present.
All members are present and the board has a quorum.
Okay, and we are going to begin with agenda item number 3, petition for reinstatement of license. And I'm going to turn it over to our ALJ, Ms. Koch Goodman.
All right, thank you very much. Good morning. My name is Erin Koch Goodman, and I'm an administrative law judge with the Office of Administrative Hearings. I am here to assist the board in the presentation of evidence and then assist them in writing the decision for their signature. This morning, prior to going on the record for the petition for reinstatement from revoked license of Natalie Ann Kolbrack, I, as well as Mr. Gatchett, on behalf of the Attorney General's office, had a conversation with Ms. Kolbrack related to evidentiary issues. Perhaps let me do this first, and that is, Ms. Kolbrack, you're sitting in front of me, and I want to make sure that you've introduced yourself for the record. If you could just identify yourself by name.
Hi, I'm Natalie Ann Kolbrack.
All right, thank you. And on behalf of the Attorney General's office, please.
Good morning, Your Honor. John Gatchett, Gatschet.
All right. The petition has been assigned a case number by the Physical Therapy Board. It is case number 2013-73773, and it has been assigned a case number by the Office of Administrative Hearings, 2018-020-263. This is the duly noticed time and place for this petition to be heard, and we are here at 2005 Evergreen Street, in Sacramento. And it is March 22nd, 2018, and just after 9 o'clock. Off the record, this morning, Mr. Gatchett, Ms. Kolbrack, and I had a discussion, really a roadmap of what we were going to be doing today. There was some information that was shared with me that I will summarize now, and that is Ms. Kolbrack brought with her additional information, additional documents that she wanted to offer to the board for their consideration. Mr. Gatchett indicated that those documents had not been produced to him or to the Physical Therapy Board prior to today, and that the board would want to investigate those documents additional. So he would object to them today if they were being offered without the opportunity to look into them and to make contact with people that are signing those documents, including letters of recommendation. There are a few other evidentiary issues that are relevant in this case, and having all of those presented to Ms. Kolbrack by Mr. Gatchett, both Mr. Gatchett and I offered two options, and that is to continue forward with the hearing today, or to ask for a continuance so that all the evidence that Ms. Kolbrack had with her today could be considered by the board via investigation by the Attorney General's office on behalf of the board. Ms. Kolbrack, is it accurate to say that you then indicated that you would like to seek a continuance and you would like to seek legal counsel for assistance in this case?
Yes.
All right. Mr. Gatchett, have I summarized sufficiently, or at least in vague detail, our discussions prior to going on the record?
Your summary is correct.
All right, very good. And so, Ms. Kolbrack, you are asking the board now to continue your hearing, and you do understand that there is not a date certain for that continuance, and that continuance will be set at the convenience of the board. You understand that?
Yes.
All right. So at this point, I think I will turn it back over to the president of the board to determine whether a continuance would be acceptable with the board at this time.
Okay. Is there a motion by a board member to accept the continuance?
So moved.
Motion made by Katarina Ellaby
I'll second.
and second by Deborah Alvizo. And so if we call for a roll call vote.
Alicia Rubina Amen.
Aye.
TJ Watkins.
Aye.
Deborah Alviso.
Aye.
Jesus Dominguez.
Aye.
Daniel Drummer.
Aye.
Katarina Ellaby.
Aye.
Tanya McMillan.
Aye.
Motion carries with a 7-0 vote.
Okay.
All right, in that case, the board has granted your continuous, Ms. Colbeck, and you'll need to look for something in the mail from the Physical Therapy Board. In addition to that, I have taken documents from you that you offered, that you wanted to offer to the board today and delivered those to Mr. Gashett. Mr. Gashett, you now have the documents that Ms. Colbeck would like to add to her petition application. Mr. Gashett, I assume that you've provided contact information for yourself to Ms. Colbeck, and Ms. Colbeck, if you'll respond to Mr. Gashett if he has further questions for you, that will make this process a bit more seamless for you, all right? All right, very good. Mr. Gashett, anything else for the record?
We're in receipt of the documents, and yes, we've had contact over the phone and email, so thank you.
All right, very good. Ms. Colbeck, anything else for the record?
No, thank you.
All right, anything else from the board this morning regarding this petition? Not seeing anyone, I'll take us off the record then. Thank you.
Thanks.
Court reporter right there, and she's going to give you a billing detail form, so if you ever needed to have a transcription of this.
Yeah. So at this time, I'd like to take a 5-minute recess just so that we can kind of regroup here, and we'll be right back in about 5 minutes. Let's see, 9:20. We're going to reconvene with open session and move to agenda item number 6, review and approval of November meeting minutes.
All right, I'm going to take that. I'm going to be Brooke right now. So I'll just go through each page, and if anyone has any comments, just stop me. So page 1. 2. I'm sorry, do you want me to use the agenda book
Yes,
pages?
please.
Okay, I apologize. So let me start from the beginning. I apologize, I'm using 2 different versions for notes and review here, because I want to make sure I'm on the same page as you. So can we start at page 10 of the agenda book? Anybody have any changes before or at that point?
Is it necessary on agenda item number 3 to have a correct name next to that title, or not necessarily?
No. Not necessarily. And in this certain circumstance, Becky Marco was actually the one who recorded the minutes.
Okay,
So-
thank you.
All right, nothing else. Page 11. 12. 13. 14. 15. 16. 17.
Page 16, under
Okay.
agenda item 18. The year there is 2018, I think it's 17.
Okay. Anything on 17? Page 17? No? Okay. 18? 19, 20, thank you, 21, and 22. All right.
Okay, any further discussion about the November meeting minutes?
Just a question to the board. One, you sure you guys don't want to change anything about the way the nominations went down or anything like that? And then second, the level of detail in these minutes, we're trying to kind of adjust that level of detail. Is this level of detail appropriate? And do you guys agree with the formatting?
Any comments one way or the other?
From a recording standpoint, I don't know that the level of detail is necessarily required. It certainly helps to refresh my memory and enables me to visualize and remember exactly where we were with discussions. And so what's captured is very helpful that way for us. If it was, and for that purpose, for us, I think that it's okay. For an external review, I think it's probably too much. So it depends on who the focus of the minutes need to be for,
Okay.
I would say.
Having said that, so there are a couple new ideas too that I just wanted to address. We're playing with an idea in the webcast of bookmarks in the webcast itself that connect back to these agenda items. So an experiment with this meeting that we're doing today will be in this webcast, where we're going to actually try to bookmark. Agenda item 3 can be found at the 33-minute and 7-second mark of the webcast, and within that document, you'll be able to click it, and it will take you to that portion of the YouTube broadcast. And so for the public, I think it'll make it much easier for those that are interested in a specific topic to be able to find that topic and see what the board, had to say about it. Does that change the idea of the level of detail? I know it's helpful for board members, and we're happy to do this, but if it is too much, I guess you could say, then we can kind of feather it down a little bit. The other thing that I'd also add is we're also going to be posting action minutes immediately after the meeting. That's a little bit different than what we've done in the past, so that somebody that is interested in a certain topic doesn't have to wait until the draft minutes come out or the next meeting, in the next quarter, that they'll actually see the motions and the voting pattern that the board had the following week, so as quickly as we can get out. And that would also have those bookmarks where they can take them to the webcast and see what the discussion was.
That kind of a format for with producing not a separate set of minutes, but the action items, I think to me, that would help, because then that provides the external piece of the actions that were taken here.
Correct.
As opposed to the grainy detail of what our discussions are, which is what this set of minutes kind of is getting closer to. So I think that to have something that's produced for the external environment, this potentially a little bit more for our benefit. I hate to look at producing things in multiple ways to say the same thing, but
Yeah, so the idea moving forward is to create that action minute document during the meeting and immediately publish the following week with those bookmarks once the webcast becomes available. And in this day and age with technology, there are still some questions that we kind of have to work through with the Department of Consumer Affairs and legal counsel about YouTube and the posting of video archives and that kind of thing. But I think the vision moving forward is, at some point, you might see just the action minutes with those bookmarks to the webcast, and the webcast essentially acts as the minutes. But the motions and the votes are recorded in those action minutes. But again, we have some questions that we have to answer about video archiving and that kind of thing before we get there. So we'll continue to do these. The action minutes we're doing anyway throughout the duration of the meeting. It's pretty simple, but I like the idea of getting it out to the public much sooner so that they understand what actions were taken here today or tomorrow. And that's all I have. Just curious.
Do those action minutes need to be approved by the board at the end of our meeting?
That's a good question. We do intend on having legal review them before we're done, but the minutes themselves and the votes, I think attendance and who voted and how is fairly, cut and dry. It's pretty straightforward. And so as having legal review them, I think that suffices, but I'll defer to counsel for her opinion.
You're looking,
Does it require a vote of the board to confirm what motions?
to do it today?
Well, it would be at the conclusion of Friday.
Okay.
We would create that document with the idea of publishing it next week online.
The concern is that, if they're voting on it, they wouldn't have an opportunity to review it at the time of the vote.
Right?
I think that perhaps we should postpone posting something like that until we have an opportunity to look into it more,
Okay.
because it is the first time I hear of it.
Sure.
Yeah.
Do that sometime.
Okay.
Yeah. I'm thinking that, since this is a test, that we let this match the video at first, and then the second step would be to edit this down and simplify this and then let the video stand. And at the same time, when I'm saying that, I'm thinking, just not to sound like too current, about privacy issues and whether, video can be manipulated. And I just became, this week, all the news concerned about any time when we go on the internet and want to post the videos for just for accessibility and transparency, that the world that we're living in may all in the interim also require, black and white back copies.
Mm-hmm.
And so I thought if we took a step-by-step approach where this matches the video, and then say, okay, now what's the next step?
Sure.
So I think the way we've been doing it, even with this level of detail, is good for us. It demonstrates probably more transparency than what is required. And moving forward, I think we could adjust a little bit on all of those ends.
Do we know if there are requirements in particular for minutes and what needs to be produced and to certify what we've done here? Can a video suffice as minutes of a meeting? Can it take the place of that or not? Those are questions that I would want to know, or answers that I would want to know before we make.
Yeah, and I'll ask Salwa too. I will say that, typically we rely on Robert's Rules and the Administrative Procedures Act, and the rules within those would, the minutes can be as simple as action minutes. There are a number of boards that's all that they provide. Whether or not the video webcast can replace the minutes, I wouldn't recommend that. I always like to have a paper guide, if you will, so that we fulfill that Robert's Rules and Administrative Procedures Act requirement of at least action minutes, and then also the webcast being provided as through that hyperlink to say, and here's the discussion that the vote came from. But I think we'll always have a document that's attached to each meeting that, is considered the meeting minutes. Salwa?
Yeah, I agree with that. Regarding what needs to be in the minutes, the board's administrative manual says that the minutes are a summary, not a transcript. So I don't see an issue with the discussion about, simplifying the minutes a little bit. Some things have to be in the minutes, like the roll call votes on motions. Jason is correct that, the board follows Robert's rules, I believe, in the administrative manual. That's what's going to be followed for this board. I would not advise against steering away from a written document. I think the webcast is supplemental, and, yeah.
I like the minutes as they are. I think because they've gone from everything from super detailed to maybe not enough. And I think we've seen the benefits of capturing the board discussion, not only for our own review, but I think it shows it's a good document by either the public or legislators, anyone that wants to see the thought process that goes on.
Sure.
And I think to ever expect that review is going to happen by somebody clicking on and sitting through a YouTube is never going to be quite sufficient. It almost gets hidden that way, and I know that's never our intent. I do think they look more detailed because of the roll call vote, and so we have to just accept that's something that has to be in there, and it's going to look a little more detailed. And I think it's the art of doing minutes, because there are sometimes we don't need the minutia. Other times, seeing what was discussed is really good history. Regarding these minutes, my only suggestion is that for the elections, I think it could be clearer, maybe just a last statement of so-and-so was elected in what position, instead of just motion carried.
That was kind of the question that I wanted to make sure that after I tried to read through them and remain kind of impartial, how easy it would be to interpret who is now the president, who is now the vice president, and so on. So we'll include that as well.
Should we go through that if we're going to approve these minutes? Because the others have a clear motion. It's just the elections, I think, that...
Yeah, do you have a suggestion, Dr. Alviso?
So for President, 28A, 5-0, Dr. Rabina Amen was elected as Board President. For Vice President, 3-2 in favor of Mr. Watkins, period. Mr. Watkins is elected as Board Vice President.
And does that motion, that motion is correct. Okay.
Because those aren't really a clear motion. It's two people up for a position.
And your motion is to, at the very last portion of this section of the agenda, to include just a statement of essentially who was elected to what and by what margin.
Or under each motion.
Okay.
I would do it within each.
Okay.
And immediately after the vote.
That's what I mean, immediately after the vote.
Okay. Any further discussion on that particular issue of the minutes? And any further discussion on the minutes themselves? And any public comment on the minutes? Okay. Do we have a motion to approve these minutes?
I move to approve the minutes.
As amended.
As amended. I move to approve the minutes as amended.
I'll second that.
A motion by Mr. Watkins and second by Dr. Dominguez. Roll call vote. Oh, any further discussion? Any public comment? And roll call vote, please.
Alicia Rabina Amen.
Aye.
TJ Watkins.
Aye.
Deborah Alviso.
Yes.
Jesus Dominguez.
Aye.
Daniel Drummer.
Aye.
Katarina Ellaby.
Abstain.
Tanya McMillan.
Aye.
All right, the minutes are approved as amended with a vote of 6 to, 0 for no and then 1 abstention.
Okay. Thank you, and let's move on to agenda item number 7, the President's Report, which is our meeting calendar.
The June dates, 27th through the 30th. What are those? What is that? It doesn't say it at the bottom.
I have the same question.
That would be the APTA National Meeting next, NEXT, the annual conference, which will be in Orlando, Florida this year.
I have a feeling that it's there in the form, but because of all the business in June, it's gotten pushed out of the cell. So we'll
Oh.
see what we can do to address that.
Okay. Any other comments on the calendar?
Any conflicts with dates for meetings that have come up or anything?
Not so far. I think we have listed here that FSBPT Life meeting is July 28th and 29th. And if I'm not mistaken, that's actually on the 14th and 15th of July this year.
We'll
So if we
confirm.
could check those, yeah. And then same with the FSBPT annual meeting. Instead of November 1st through 3rd, it looks like it's at the end of October this year, 25th, 26th, 27th.
We'll confirm and make that correction.
Okay. Any other comments on the calendar? Any comments on coming in for Thursday and Friday versus Wednesday and Thursday?
Yeah, I'm interested to hear how that went.
We don't know yet?
Besides the weather.
Traffic here was no different, I don't think,
Okay.
from Tuesday night to Wednesday night
Sure.
for travel from
Tomorrow
the Bay
will be
Area.
the tell.
Friday going home will be a different story, I'm sure.
Okay. Any further discussion? Any public comment? And this is an adopted calendar, so we don't need to.
There were some amendments.
Right.
So
That we need to verify.
Yeah, so I'll make the corrections for adding APTA next and confirming both the LIFE meeting and FSBPT's delegate assembly. And after making those changes, the board will need to make a motion to accept with those amendments.
Okay. Okay. Is that something we'll take later, or,
I think you can do it now.
oh, okay.
So reviewing the FSBPT website, the Leadership Issues Forum is July 14th and 15th in 2018 in Alexandria. And the annual meeting and delegate assembly will be October 25th through the 27th in Reston, Virginia.
Thank you.
Okay, do we have a motion to adopt this calendar with the amended dates?
So moved.
And I'll second it.
Motion made by Ms. Ellaby, second by Mr. Watkins. Further discussion? Any public comment? And roll call vote, please.
Alicia Rabina Amen,
Yes.
TJ Watkins,
Yes.
Deborah Alviso,
Yes.
Jesus Dominguez,
Aye.
Daniel Drummer,
Aye.
Katarina Ellaby,
Aye.
Tanya McMillan.
Aye.
The vote was 7-0, and the calendar is adopted as amended.
Thank you. Okay, let's move to agenda item number 8. And if I can invite Dr. Alviso to the front of the dais, please. If we may be here, front and center. jotted down some notes.
Uh-uh.
Back here? Okay. Let me stand next to Jason. Dr. Alviso, it's only fitting to thank you for your public service, the many years that you've been given to the PTBC and doing so publicly. You were appointed when?
2006.
2006, and you didn't run away. And not only did you not run away, but you chose to stay and serve the maximum allowed time that you could. And during that time, you've worked diligently on behalf of the board and the consumers of California. I believe all of us came onto the board, if not most of us, when you were president. And you were a true example of a model board member. And even as you stepped away from presidency, you remained a respected leader amongst all of us. Your remarkable contributions have not gone unnoticed, and we're proud to have served with you. So on behalf of the board members, and if I dare to say all the board members who served with you in the past, we want to thank you and wish you the best as you go forward.
Thank you.
We're going to miss you.
Thank you.
Mhm.
With that, a commendation from the Physical Therapy Board of California, signed by all of the existing board members for your service. 12 years.
Woo! Thank you.
Thank you. Thank you. I probably just missed a moment, so I'm going to take it. I'm usually a pretty quick draw on the microphone, so I'm going to go for it. Thank you very much. There's a potential that I still have another meeting or so, but this is kind of my last time to be here in Sacramento, and the board staff that's here, I just want to thank you all. The work that gets done here just starts a cascade of work that gets done by all of you, and everything that's good about this board is because of what the support that you guys do and the real work that you're doing. It's been an honor to work with all of you. I've met some amazing people, dedicated, and this has been like a real important part of my career. So thank you very much, and I'll be watching you guys. I'm going to tune in, keep an eye on you. I'll now be under public comment, so thank you.
Okay. Let's see. Mr. Kaiser, do you think we should maybe move to agenda item number 9 for the executive officer's report?
I think I can do that in the time allotted. So before you have what you're used to seeing in my report. What you have before you is what you're used to seeing in my report, some highlights that I've taken from other reports from staff, administrative services, those kind of things, welcoming some new additions and some promotions. Most notable is the addition of an outreach coordinator. Alicia Miller has joined PTBC to kind of tackle some of those things that we've talked about in the past, where we think we could do a better job in getting information out to all of our stakeholders. And we have already made quite a bit of progress in that short period of time that she's been here. And kudos to her. Her first day on the job was a presentation at UOP in the evening on her first day working with PTBC. So, and she was eager to tackle it. So that's, again, much respect to her. Since then, it hasn't changed much. We've been to Fresno State, Sac City College's PTA program the night before last until about 8:30, in the evening. And again, having her there to keep this kind of project organized and running, you've seen some end results already. The About Us is now published, a better rebranding of the social media pages. Things are looking much more uniform. The next project really is tackling the website and creating some fluidity and some more appropriate internet protocols and etiquette so people can find information that much better. So welcome to Alicia. We love having her here. One of the other things that I might look at and point out as a highlight is we did hear back from Solid today about the strategic planning session. We got quite a bit of feedback, and so it's taken them a little bit longer than anticipated to collect that data and create the environmental analysis. But they're just about done. And so they'll be providing that to staff for us to create a draft of the plan that we will be distributing out to you ahead of the April 12th strategic planning session. The original plan essentially was to try and provide that to you even before today's meeting. But again, we took a big chunk. We got quite a bit of feedback. We surveyed close to about 30,000 people in total. So, and a lot of them took the opportunity to provide comment. So them collecting that data has been very important to us. But unless there's any questions that you might have regarding the executive officer's report, I'd be happy to answer them.
Any comments or discussion from board members? Any public comment? Thank you, Mr. Kaiser.
You're welcome.
So it looks like at this point in the agenda, we can move into closed session. We're going to be taking agenda item number 10, the legislation report, after lunch. So we can move into closed session now and reconvene. What would be a good time to reconvene?
1 o'clock.
Maybe 1 o'clock? Okay. Before we go?
If I may. So I'm prepared to discuss, but I wasn't expecting the petition to end that rapidly. So if we could do
We have enough room. We have a session tomorrow.
So then that way, the break that we could take based on that. So, yeah, if you still want to do 1 o'clock, that's fine with me, but I just wanted to let you guys know that I would do a proposed decision.
And then we also have Nicole Lee from DCI coming. We'll discuss the...
Okay. Yep. So we will reconvene at 1 o'clock. Okay, thank you. Okay, we're back from recess, and the time is 1:03. We're going to pick up with agenda item number 10, the legislation report.
So February 16th was the last day for bills to be introduced, and currently the legislature just began spring recess and will reconvene on April 2nd. June 1st is the last day for each house to pass bills introduced in that house, and October 15th is the last day for the governor to sign or veto bills passed by the legislature on or before September 15th and in the governor's possession after September 15th. On page 30 of the meeting materials is the legislative summary, and I'll go ahead and go through each bill. So AB 2078, Sex Offenses Professional Services, would expand the crime of sexual battery to apply to a person who performs professional services that entail having access to another person's body and who touches an intimate part of that person's body while performing those services. This bill would also expand the definitions of the crimes of rape, sodomy, oral copulation, and sexual penetration to include any of those crimes performed against a victim's will by a professional whose services entail having access to the victim's body. This bill is still currently at the Assembly Public Safety Committee. AB 2138, Licensing Board's denial of application criminal conviction would ease the licensing restrictions on former offenders. It would prohibit a person from being denied a license solely on the basis that he or she has been convicted of a nonviolent crime and would make conforming changes. This bill is also still in the Assembly Business and Professions Committee.
For that particular bill, we've seen language like this in the past that kind of takes that, You might remember the expungement legislation that went through. It lessens our ability to take any kind of action on a sole conviction. And in this case, as far down as is nonviolent crime. I know that the language is ever evolving. It's early in the session and things are changing, but this is something that I think that I would urge the board to watch expressly. And even at this, we've heard from the legislature that sometimes boards or bureaus don't come into or provide opinion early enough in the session to really make an effect. And so please take that into consideration too. But this is something that would really hamper our ability in the enforcement program to even investigate something that could be extremely egregious that the board may consider a harm to consumer protection.
I'm just wondering what others' perspective is. In my reading of this, or at least of the summary, is that the license can't be denied just because somebody had a conviction. Not necessarily not necessarily determining that what the conviction was about and what the circumstances were. That could be taken into account, and a license could be denied based on the circumstances. And just using the fact of the conviction is what couldn't be used.
Correct. So you always have the underlying acts. And the unfortunate part of that is we would have to prove those underlying acts. So we would not be able to take the work that has been done by our sister courts and just use it as an affirmation in our action. We would have to subpoena witnesses, bring in arresting officers, essentially prove the case in the administrative level without the weight of the conviction. And that's been the issue that we've had in the past with the expungement idea and those kind of things as well. It would create a burden on the boards and bureaus of having to administer that process that it's really hard to determine how it would extend the length of time of processing that application and what the cost entailed would be involved.
And our current determination is that it's the obligation of the applicant to prove that they are worthy of licensure.
Assuming that the denial was processed correctly, yes. So if you have a substantial reason to deny an application, it's then shifted the burden of proof onto the applicant to prove otherwise. But there is a potential that we could abuse that power to deny by not having the right reasoning to deny.
And if an applicant has been convicted of something, when they're required to disclose the nature of that conviction, the circumstances that are behind that, correct, on their application?
Correct. But this could change that process as well. The effects of this bill could lessen our ability to ask that question on the application.
Thank you.
AB 2221, Occupational Therapy Practice Act, will update and modernize the Occupational Therapy Practice Act. The Occupational Therapy Association of California and the American Occupational Therapy Association are proposing amendments, which include the revision of outdated definitions, clarifications of provisions related to advanced practices, revision of continuing competence and coursework requirements, and clarification of the provision of mental health services by occupational therapy providers. This bill is still in the Assembly pending referral.
Ms. Defoe?
Good afternoon, everyone. I'm Stacy Defoe. I'm with the California Physical Therapy Association, and we, as an association, haven't taken a formal position on this bill. It hasn't. The language hasn't been released fully. Right now, it's in a spot form, but we have been in communication with the with OTAC regarding their intentions for this bill. It's our understanding that they are working on a modernization of their Practice Act, very similar to what PTs and others have done in the past. And language will be forthcoming shortly. So.
So with our summary, Brooke, there's a statement that this bill would make, and this is from the spot bill, I'm presuming, that this bill would make non-substantive change in the act. But if this is a modernization of the act, then that statement is likely not going to be correct, not going to be a true statement, and that there will be significant changes if they're updating their Practice Act.
They will be substantive.
So we'll watch that. Thank you.
Okay, the next bill is AB 2386, Teacher Credentialing Services Credential with a specialization in occupational therapy or physical therapy services. This bill would require the Commission on Teacher Credentialing to develop a services credential with a specialization in occupational therapy or physical therapy services and would establish the minimum requirements for the credential. It also requires the Commission to authorize any person with at least 5 years of experience providing occupational therapy or physical therapy services in a public school setting to apply for the credential. As of March 1st, this bill was referred to the Assembly Education Committee.
Again, Stacy Defoe, California Physical Therapy Association, and we are one of the sponsors of this bill, along with Occupational Therapy Association of California. And we're moving this bill forward in order to give physical therapists and occupational therapists working in the school system an opportunity to have a career path in that system, which currently they really don't. They're hired as consultants, and there's no way for them to really move forward from that. And then also to have the opportunity to have more of an impact on policy and policy changes that are made and considered in regards to physical therapy and occupational therapy in the school system.
And then it's my understanding that currently speech language pathologists or speech therapists do have the ability to take these positions.
Correct. And this language is modeled after that. Thank you.
AB 2423, Physical Therapist Direct Access to Services, Plan of Care approval would exempt patients receiving physical therapy services as part of an individualized family service plan or an individualized education plan pursuant to the federal Individuals with Disabilities Education Act from a treatment limit prohibiting the physical therapist from continuing treatment beyond 45 calendar days or 12 visits. On March 8th, this bill was referred to the Assembly Business and Professions Committee.
Stacy Defoe, California Physical Therapy Association. This is a bill that we are sponsoring. And as mentioned, this bill would create an exemption in 2620.1 to the current 45-day, 12-visit time limit that is there for patients who seek physical therapy treatments directly. And it's a very narrow exemption for a very narrow population of children who are under an IFSP or who are under an IEP in the school system. And we think it's important to create that very narrow exemption because with this time limit, PTs working in that system are sometimes unable to provide the services that the children are required to have under federal law because the time limit precludes the physical therapist from even participating in the IEP because the IEPs are generally developed from 6 months to a year. And with that time limit sort of looming, it creates a situation that's untenable for the PT. Do we go ahead and create this IEP for the whole year, knowing that we may run into this this time limit, or or what do we do? And then oftentimes the physical therapists will find themselves between the school legal counsel and state law. And the two are sort of combating each other, where the legal counsel is telling the physical therapist that they need to continue services regardless of what the state law is saying. And so our goal is really just to clarify that, that in these circumstances, the physical therapy can continue for those students in the school system.
Stacey, I have a question. So you're citing the 45 days, 12 visits. How did this system function before those limits existed?
Very similar to what's happening now, but I think what's happened is that in recent history, we are seeing more and more students running into the need to be under the IEP and or IFSP, and it's just it's a situation that's coming to a boil. It's something that's always been, I think, an issue, but with this, since the time limit, it doesn't really have as much to do with the time limit. That's the current impediment. It just has, I think, more to do with the time in history, as it's just become more of an issue for more students in the school, and it's become more apparent that we need to do something to try to address it. I think we'd be here whether or not we had that 45-day 12-visit time limit.
And I think when you shared this with us before sunset, I think one of the issues was that the availability of physicians or their access or something. I mean, is there
that's
part
correct.
of the issue?
Especially if in rural and urban settings in particular, where you're going to have more students who are getting services from Medi-Cal and those kinds of services, getting back to a physician for those students is sometime, and their parents is often a hardship. Either they can't do it in time, they don't have access to a physician. Often, like I said, it's a timeliness issue, but that is a problem for those students, getting back to the physician for a visit or a diagnosis in the first place.
One of the things that came up when we reviewed this through the sunset process, and in my review of the bill itself, I think there's an intent in this language that's not expressly stated. When we reviewed this during the sunset process, one of the difficulties that we came across was the difference between medically necessary treatment and educationally necessary treatment. In the event that it's medically necessary, we're fairly certain that there's a diagnosis somewhere that our practitioner can rely on. When it's educationally necessary, they can treat for that 12 or 45, right? And then they have to go get a diagnosis, and the lack or the access, the time limit in between, the pressure being applied because of the conflict of law is really where that frustration built. And there is a disservice, I think, being done to the students at that point. I think what's interesting here is while that's not expressly stated, they have included the exemption right next to the exemption for wellness. So, and I think there's a parallel there to be made, because we're not requiring or asking our practitioners to have a diagnosis when they're treating a patient for wellness modalities. And in this case, because it's educationally necessary but not necessarily medically necessary, that might be an equivalent.
That's an excellent point, and that is part of the intent. Oftentimes, the services provided are educationally necessary. They've been diagnosed by somebody who isn't even authorized to provide a medical diagnosis. It's not a medical diagnosis. It's the student has been diagnosed with something that is impeding their educational success. And the physical therapist may be able to provide services to allow that student to access the education that they're entitled to. It's not even necessarily a medical issue. or a medical diagnosis per se. And I think it's true to say that in most cases, the student that comes with a medical issue, there is a diagnosis that can be located somewhere, and the issue that follows that, though, is getting that written diagnosis. So even if there is a diagnosis that we know is following that student, sometimes getting a hold of that written copy for those students who don't have quite the access to it is an issue as well. Are there any questions?
Stacy, I had a quick question. I've never functioned in the school system, but could you give us an idea, or at least me, could you give me an idea of what that looks like? So Mr. Kaiser said under the wellness assumption, what role would physical therapy have in the IEP?
They may be able to authorize specific equipment that the student can use to sit appropriately in the classroom. They may be able to work with the physical education teachers to help the student be successful in those activities. If the student is maybe having some balance issues or things like that, they can work with the faculty there to make sure that the student is able to participate in those activities safely. Those would be a couple of examples. If it's a student with maybe who's autistic, been diagnosed that way, they may be able to give them again some appropriate seating or something to play with, or there's a number of things that the physical therapist can suggest and implement to help the students in those situations.
And if I remember correctly in our previous conversations, the team that puts the IFSP together, the IEP together, that orders or requires those physical therapy services, two things. One, maybe nobody in that team has the ability to diagnose.
Correct.
Or because it's in a school setting, those that are licensed and able to diagnose, because it's in a school setting, are prohibited from doing so.
Correct. That is correct. And the purpose of the IEP is to make sure that the child has what he or she needs in order to access the education. So it's not always a medical issue per se. It's just whatever it is that it's impeding that child's ability to be successful in the educational setting.
So kind of adding to what you're saying, also the professional that's treating somebody, if this were to take place, would still have that responsibility that if something did not seem right, something was an immediate change, they would be obligated to direct that person back to.
That's correct. That's a professional responsibility that's there regardless of the time limit or any of that. And it's already written out that that responsibility is explicitly written out in current law. That's not changing.
And I would state that in our research from Sunset, the ADA Act states that those licensees are still bound by their own practice acts and the laws and regulations from that practice act. So even in situations like this where you might get the exemption really is for the absence of the diagnosis.
That's
All
correct.
of the other PT practice laws apply.
That's correct.
And it's my understanding, too, that very often, especially pediatric cases, there's a reluctance to provide a diagnosis because the child may be too young to be able to have something fully established to determine a medical diagnosis. So very often providers won't do that
That's
for
correct.
a period of time.
And yet there are still services that the physical therapist can offer to help the child be successful.
I'm inclined to take a supportive position on this bill, but I'd like to see how the other board members feel.
I would support it.
Any other discussion? Any public comment? So we need a motion. Yeah, we would need a motion.
So moved.
Can you say in more detail?
Sure. I move that we take a supportive position on AB 2423.
Second.
And with that supportive position, you'd like us to draft a letter on behalf of the board and send to the author?
Correct.
Okay.
Thank you, we appreciate that.
Okay. Any further discussion on that?
I know that, guess I'm wondering if there's any sense that this will be changing significantly. I mean, whether this is an early time to provide support, or
At
whether
this
it would be
point-
helpful at this time.
At this point, there isn't an intention to change it.
But your
But
point,
as we move forward, we never know, what's going to come up. But at this point, our intention is to move it as it is.
but your point being well taken, it's very early in the session. It's not unusual, though, when a bill is significantly amended for a board to be in the position of changing its position.
I wouldn't want it to harm things to look like we support it and then we move away.
Yeah.
As opposed to at some point saying, we support this. So whatever is most strategic, I say.
We could take a position of support unless amended. And then that would draw us to reconsider it.
You just created a new classification.
I like it. I think it's
Something that I didn't think you'd be able to do.
You of little.
Contrary.
That's funny.
support is always appreciated. I think the understanding is there, though, that if there were substantive changes made to the legislation, that the board would need to reconsider. I don't necessarily think that would be harmful at that point. That would just be, I think, something that's fair for you to do.
I'm a little conflicted either way, only because I agree with Deborah. It's very early in the session, but I also have this little voice reminding me from the legislature in the back of my head that they want to know as soon as they can. And if that's the case, if I had to choose all bills to come up with this idea, this is one where I think I'm a little bit more comfortable with it, because it's actually solving a problem. And then again, with the reassurance that if anything did change significantly, that we would have that opportunity through the session to adjust.
I think the letter of support will state the spirit that we're behind, and if that were to change for a technical reason, then I think that could be explained.
Any further discussion by the board? And any public comment? Okay, so roll call vote.
Alicia Benayemen,
Aye.
TJ Watkins,
Aye.
Deborah Alviso,
Aye.
Jesus Dominguez,
Aye.
Daniel Drummer,
Aye.
Katarina Ellaby,
Aye.
Tanya McMillian.
Aye.
Thank you. That is 7 to 0, vote carried.
Thank you, Stacy.
Thank you.
Okay, so AB 3013, Veterinary Medicine, Animal Rehabilitation would authorize a licensed physical therapist with an advanced certificate in physical rehabilitation to provide animal physical rehabilitation to an animal if certain conditions are met, including that the animal physical rehabilitation is performed on a veterinary premise registered with the Veterinary Medical Board, an animal rehabilitation facility registered with the Veterinary Medical Board or a range setting. We have proposed amendments to the bill that have been disclosed to staff after dissemination of the meeting materials. Please refer to the handout that we just provided. One of the new amendments is on page 2 of that handout, and it's that the author will be striking the proposed amendment in our Practice Act, BPC 2620, referencing an animal of practicing under section 4828.5 has been removed.
So on a topic that you are familiar with over time, and we have Karen Atlas here with us. We also have Ethan Mathis from the Veterinary Medical Board. While I appreciate them not, creating any effect of our Practice Act, there are still a few points of concern that I'm wondering. The language expressly states that animal rehabilitation certification would be created through regulation in cooperative with the Veterinary Medical Board and the Physical Therapy Board of California. And I guess the only question that I have is, what would we be able to provide on the human side to determine what is needed or should be added to, what advice we could provide in creation of that specialty education to attain the certification?
Would you like public comment at this point?
I'm just waiting for the board members to.
I have a question. This is, I'm sorry if I should have seen this text before, but on page 3, under section 1, so about line 12, when it refers to an animal physical therapist, is that, trying to figure out if that's a new term or if that's a physical.
My assumption is that that is a physical therapist that has that specialty certification as defined by VMB and us. But if the question is whether or not using that language is a conflict with our existing statutes.
Well, I guess I'm not having looked at it thoroughly enough. I'm wondering, does that phrase only apply to physical therapists that meet this criteria, or would another kind of person that meets the other rehab criteria be called an animal physical therapist?
It's a good question, because I'm not sure in reading this language that there is an opportunity for anyone other than a physical therapist with specialty education to become an animal physical therapist or an animal rehabilitationist, if you will. Is there an avenue for a layperson with similar education to also attain that certification? I don't know. But we had also discussed in previous conversations of whether or not using physical therapist in someone else's Practice Act would be allowed given the title protection. In this case, I don't think it's an issue. One, this is someone else's legislation, right? It's not a title that's being used. Similar to the Chiropractic Board referring to physical therapy modalities, right? It's not really a conflict about the title protection. But here, it does beg the question, is an animal physical therapist a licensed California physical therapist with special education? Or is there another avenue to attain that certification?
You know what, maybe page 2 might make that
Can
clear.
I interject here? The language that you're looking at is those amendments haven't gone through yet, so it's a little bit in flux. And I wouldn't pay too much attention on the animal rehabilitation or the animal physical therapist language. The intent of that language was really to remove animal from the PT Practice Act. And we are still in discussions with CAA, APT, CPTA, the author, as to how best then to address it. It probably won't look like animal physical therapist at the end of the day. It'll probably just go back to the language that was initially sent over, which is physical therapist with a certification, animal rehabilitation. So I don't want to get too hung up on that. And I think that's probably where it's going to end up because of questions like the ones that you're asking. Is this creating a whole other a whole other group of physical therapists now called animal physical therapists. That's not really the intent. The intent is just to say a physical therapist who is specially certified and authorized under the vet board can provide these services. And so we're working on that language.
And I'd also say we have an appointment with the author in the next coming weeks also. So there's some clarity that we can get there too.
Yeah. So I just didn't want to get too far down that line because there's a strong likelihood that that's going to change.
Can you provide any insight into how this board would be able to help determine what education is needed for that specialty certification?
I'd like to defer to.
Yes, I can. I'm Karen Atlas. I'm a physical therapist, licensed physical therapist in the state for past 20 years, and I'm the president of the California Association of Animal Physical Therapists, and we are the sponsor of AB 3013. And the reason that we would really like to have the physical therapy board in cooperation with the veterinary medical board to determine competency standards is because it has been shown that there really isn't an in-depth understanding on the veterinary medical board side of our competency and education. And so with that, I think it would be in the best interest to have the two boards working together to because really this does come between two, this language falls in between two boards. And so in order to have the language come together for the best interest of the consumer, it would be good for the board to be working together to figure out what that language would look like. And since the veterinary medical board doesn't have the same type of understanding that this board does, it would be very helpful to have this body working collaboratively with the veterinary medical board. It's also been recommended by the chief consultant of the Senate Business and Professions that he would like the boards to work collaboratively as well.
Any board discussion or questions? Any public comment? Any comment from Vet Med Board at all? No?
Ethan Mathis, Veterinary Medical Board. We are aware of the language. It is new, as we all have said. The board has previously worked on language in relation to the physical therapists working as in cooperation with the veterinarians, and there was numerous task force that we went through and numerous board meetings where the board did determine that they felt that direct supervision would be required for physical therapists, and this is somewhat in conflict with that decision the board has made. So we definitely are looking at this, and unfortunately, because the language is new, and I just saw this language for the first time this morning, I can't really comment too much on more than what I've already said.
Mr. Mathis, if I recall correctly, there are actually regulations that are in process right now that were contingent upon those task force decisions. And that's the biggest.
That is correct. Yeah, throughout the task force and multiple public board meetings, we did craft language stating what I had stated about direct supervision. And those are on the board's docket to effectuate.
And one of the biggest differences between that language and what's being proposed in this legislation is that level of supervision.
That's a very big difference, yes, and very concerning for the board.
Could I interject regarding the task force and that it was mentioned and the board, the regulations that the board is promulgating are quite different. So yes, there was a task force that was created.
Absolutely.
And the task force did make recommendations to the vet board. And those recommendations did not require direct supervision. The recommendations that came from the task force allowed the veterinarian to determine the level of supervision, which is something that CPTA and CAAPT was in favor of. So the language that you see is really based on what the task force came up with, just to clarify. What the board is promulgating is opposite to what the task force recommended.
And just to make another clarification, if I may, that this animal rehabilitation task force was a legislatively mandated task force because of the Veterinary Medical Board's sunset review. So this was a legislatively mandated stakeholders task force. And so all of this language, the full intent of this language is to just codify the language that was agreed upon in the legislatively mandated task force.
I have a question. Are you the EO for the vet board?
That's correct, yes. Yeah.
Can you share, thank you for coming, can you share some information with us about the decision-making behind the proposed regulations?
The ultimate regulations, some of our concerns were the training aspect. And I mean, obviously our mandate is consumer protection. So that was the overarching idea, is making sure the animal patient and the consumer is protected. So some of the discussions were directly related to what has been said already, is the certification program, what that would look like, and also the fact when we talk about supervision with veterinarians delegating tasks, there's concern that when you indirectly supervise, there's some liability concerns and confusion on the consumer's part for who's responsible ultimately for that treatment.
And currently, veterinarians supervise or are allowed to supervise who?
Within the veterinary medicine field, there's veterinarians, there's veterinary technicians, they're also licensees, and there's an offshoot with veterinary assistants, but basically anybody else that's in a veterinary premises, otherwise practicing veterinary medicine, is considered a veterinary assistant, and they're unlicensed, and that's where the board landed, was these are de facto veterinary assistants.
And veterinary technicians go through some education program?
Absolutely, yeah, 2-year programs, yes.
2-year.
Yes.
Okay.
It's very similar to our model, PT and then PTA, the registered veterinary technician, lower level of education, and then very similar to the way we see things. Anybody else in the practice is potentially a physical therapy aide. In their case, they would be a veterinary aide. It's a precarious place to be in, because essentially what VetMed's doing is carving out a licensure exemption under their Practice Act. But I think it's agreeable amongst all parties that the physical therapy that's being conducted on animals is the practice of veterinary medicine. It's just a question of where the level of supervision is going to be applied, given that carve out or that exemption in the VMB Practice Act.
And also notable in terms of the liability piece, there was language in there that was clear about the liability, so that there would not be a confusion on the consumer's part on who is liable, because there was some clear language in there that stated that the physical therapist would be liable for the physical therapy aspect of treating the animal.
And you're discussing the recommendation from the task force? That's the language that you're referring to?
I'm sorry, the language that is in the bill language. The task force language did not talk about liability, but we did understand that was a deep concern of the vet board, so we wanted to address that concern and put it in there right away, that the liability piece should fall onto the physical therapist, so that the consumer would have a person to make their complaint against.
If I could interject on that real quick. The language also talks about establishing a veterinary client-patient relationship, which establishes some terms of control over treatment, and that was also in the bill. So that would be one of our concerns about that. VCPR would still need to be established, which determines somewhat the liability and who's authorizing treatment.
Which I believe would be likened to what we have in the human model, right? So you have the physician referring to a physical therapist, but it's not the physician's liability of whatever happens on the physical therapist's premise that, it's not going to be the physician because he referred the patient. We are definitely in support of the VCPR, the veterinary client-patient relationship, and we think that should stay intact in terms of having the animal medically cleared and have a clear diagnosis for the animal and then be referred by the veterinarian, but just so that and then the veterinarian would remain in control in terms of deciding the level of supervision. So if the veterinarian does not feel that that animal is safe under an indirect supervision model of a physical therapist, then they would not make that referral. So the veterinarian would stay and remain the gatekeeper of services. And if the animal is too fragile to be on an off-site location from a veterinarian that would be on premise, then the veterinarian would simply just not make that referral and keep it in-house in terms of, or maybe it's just not an appropriate case for a physical therapist under indirect supervision.
And with hearing that, I'm assuming that that's not new to your ears and the Veterinary Medicine Board's ears. What about that statement is not acceptable or is of great concern that that they've decided to promulgate regulation for direct supervision?
For direct supervision?
I'm sorry.
Pardon me.
No.
Why did they choose direct supervision?
So with what she just said, I'm assuming that that's not new wording to the Veterinary Medicine Board's ears or your ears. What about that is of concern so that the Veterinary Medicine Board has decided instead to promulgate regulation that would require direct supervision?
Well, I'll go back to what was discussed.
Please.
Why they determined direct supervision was having control over the treatment and any other thing that could possibly go wrong within that treatment. With the veterinarian delegating to the direct supervision, they want to make sure that they're available in case, worst case scenario type stuff. If something goes wrong, they thought that would be appropriate based on their training and the potential for whether that training is conveyed to the animal physical therapist.
And so it's not. So the veterinarian who delegated that responsibility for that patient to the physical therapist or to the therapist who's the rehabilitation therapist, that veterinarian should not have that authority, should not have that ability to make that decision.
No, they should have the authority to. Anything like we talked about, anything that's not licensed is a veterinary assistant duty.
Right.
And that's what we're talking about. The veterinarian is delegating animal health care task that they feel the person being delegated to has the ability to do that particular task.
But currently, the veterinary assistant is directly supervised.
Correct.
Right.
Yes.
The light bulb went on over here, so thank you.
Ms. Alice, just a clarification, if I understood correctly, and it might not be in the language here, it might be the intent, but the language that I have in front of me, I don't see the authority for the veterinarian to choose the level of supervision.
That is, so if they make the referral, then it would be under indirect supervision, but they can choose not to refer, which would be a direct supervision.
And then just treat it as
so
a
they're
veterinarian assistant.
Correct. So they're continuing to, so in essence, the spirit's still there that they get to choose whether they want to refer or not. So kind of the rub here is that folks with our level of training and expertise are being lumped into an unlicensed assistant category. So we're relegated to basically an aide. And there has not been any sufficient proven evidence that any harm has been made. I reached out to the 7 other states that have this indirect supervision model by referral, and each state board authority, I contacted all of them, and they all reported that they've had no incidences of harm or negligence, and not even one complaint against a qualified physical therapist practicing in this setting. So I added up all those years, and it's over 70 years of exposure in this field with other states that have had this model and not a single complaint, much less a single disciplinary action. So the point of that there's potential harm and safety, we just have not seen that in the factual evidence. So is there potential? Well, there's also potential to have harm at a groomer's or at, crossing the street too. So in terms of looking at the specifics of this model in other states, there has been so many years of exposure here, and the evidence is just not there that this is an unsafe practice. So we're just trying to expand the access to qualified practitioners and provide a little bit more choice for consumers to decide who they want to have treat their have them treat their pet. And but we also recognize that we do need to have a veterinarian involved and determine that level of supervision. So again, that level of supervision can be direct, which would mean that they would not refer, or indirect, and they could refer.
And I only have one more question. And this is just a concern from kind of the administration of a program. There's language in the current revision that states the board shall have the exclusive authority to discipline an animal physical therapist consistent with this chapter. And I guess my concern there is similar situation, although no animals are involved, is when I have a physical therapist who may have committed a violation in another jurisdiction, another state, this board has the opportunity to consider its consumers and sanction that licensee as well. And the way that that's stated, I wonder if that's still allowing this board to take any kind of actions that the VMB might take against an animal rehabilitationist and act on it as well.
Yeah, I like Stacy alluded to, that this isn't any language that you can hang your hat on right now. We're in the middle of amendments right now, and so we found that also that we wanted to amend this. So we didn't actually we didn't anticipate that this language would be before the board, because it really is an amendment phase right now. And so what we're really trying to do is trying to figure out the right language to codify what the Animal Rehabilitation Task Force has already agreed upon, and figuring out what that perfect language is still in limbo. And so I would encourage you to not hang your hat too much on that language right now, because
But that concern is noted.
Yes,
Yeah.
Thank you.
Thank you, because while I agree, we're very early in the session, that would be something that we would watch out
And
for
agreed, yeah.
during the process.
I just have one more question about the board's proposed regulations. Have they taken into account the range setting and what kind of supervision there?
I can't remember off the top of my head what the exact language was, but yes, we took into account range setting. It was something to the effect of available in a range setting. A veterinarian would need to be available.
Thank you.
I can comment on that a little bit more, which is an interesting note here, because for the part of the language that the board is promulgating right now, it would put physical therapists with advanced training, or physical therapists, well, in their language, we would still be an unlicensed assistant. So we would be put under direct supervision for a small animal setting, but they had proposed that they want to put indirect supervision for a range setting, which is an interesting approach to separate species now and determine regulations based on species. So it's unclear why it would be okay with a small animal to be under, to have direct supervision under a small animal, but then have a more liberal view of just having him be in the vicinity of for a large animal.
So I know I said I was only going to ask one more question, but Ms. Alice, I'm curious. Your association has an acronym.
Yes.
What is it?
The California Association of Animal Physical Therapists, CAAPT.
And as a representative of that association, do you have an opinion or a stance on the idea of, and this is just for my own curiosity, I'll preface that, animal rehabilitation being provided by lay people that have similar education to that of an animal physical, or a physical therapist with advanced special certification?
I have very strong feelings about that. I think that it should be regulated so that in the spirit of consumer protection, that a human physical therapist should get all of the additional training to work on animals and go through the criteria that would be hopefully established by the two boards, and that no other type of practitioner can perform these services.
And so I'll probably have to rephrase that just to make that clarity.
Oh, okay.
And I can use a pretty good example. So somebody who has a doctorate level physical therapist
Right.
Degree, but not necessarily a license with the PT Board of California, could they still, in the position for your association, would that be okay for them to attain a license not a license, but an advanced special certification from VMB?
No, I think they should be licensed under the state of California.
I look forward to further reading to see what new language comes around.
Okay.
Stay tuned.
Can I say one more thing? Okay. The Veterinary Medical Board, when they were looking to make new regulations for just the physical therapists, they were stopped in this because another licensed professional can't have purview over another licensed professional, which is why we need to go through a legislative statute. However, when they were looking at the regulations, they agreed upon that a licensed physical therapist with all the additional training could work under direct supervision in the small animal setting, but indirect supervision in a large animal setting. And I find it interesting that it's very similar to, they actually had higher standards for a physical therapist to work in this level, in this industry, than just an unlicensed assistant, because when they were doing the unlicensed assistant language, they just said that they could be under direct supervision. But if you're a physical therapist, you had to have additional training to be under direct supervision. So I found it interesting that if you're a physical therapist, you actually have to have additional training in animals to still be under direct supervision. But if you're an unlicensed assistant, then you have to be under direct supervision as well. So I found that an interesting aspect of their language.
Any other further board comment? Any public comment?
Okay, and the last bill on the legislative summary On page 35, AB 3110, athletic trainers. It's similar to bills introduced in previous sessions and would create a new license category for athletic trainers under the California Board of Occupational Therapy. On March 12th, this bill was referred to the Assembly Committee on Arts, Entertainment, Sports, Tourism, and Internet Media, and also the Assembly Business and Professions Committee.
So I'm Stacy Defoe, California Physical Therapy Association. We currently have an opposed position to this legislation as written. This bill has come forward in many iterations, but all very similar. And again, we feel that the language here is overly broad. We aren't sure how it really relates to athletes. It's athletes is mentioned in a couple of places, but really it seems to be any person, could be seen for pretty much any reason. There's nothing really that differentiates what's here between what physical therapists do. We do see the value for consumers of knowing who it is that's treating them or their children. And we think that that goal, along with the issues that they've raised about traveling to other states, could be accomplished through title protection. So if that's something that we would be open to discussing, but currently the bill as it's written, we would have to oppose.
You mentioned that you only saw the term athletes in a few places in here. So are you under the understanding that athletic trainers only work with athletes?
According to our understanding is that's what they're educated to do, is to work with athletes. So yes, as far as the bill is concerned, and legislation that would apply to athletic trainers really should be specific to athletes in an athletic setting.
And so are you asking for a definition of athlete in this?
I think there is, but it's very broad. And the athlete, the way it's been defined, is really anyone engaged in an athletic activity. And what is an athletic activity? It's anything. It's walking, it's standing, it's breathing. So it's so broad that it really could apply to anyone at any point in life doing anything for any reason. It's very broad, and there's no real level of oversight or supervision either.
Mr. Foe, when you state overly broad, is the concern of the CPTA that athletic trainer would also be able to provide similar services that other like practitioners might be providing? Correct. So in the case of treating pain or, range of motion or performance or something like that?
That's correct.
My read of the language of the bill actually didn't show the word athlete at all. Mm-hmm. The word athletic activity is what's used on several occasions, and it's near the very end of the bill that athletic activity means participation in activity requiring physical strength, range of motion, flexibility, body awareness and control, speed, stamina, or agility.
So
that's a very broad definition of what athletic activity is, and in my mind includes the elderly patient that I have in the hospital who suffered a stroke and now has hemiplegia and has inability of her brain to tell her body how to move. And I'm not aware that an athletic trainer has the scope of education to be able to treat that person. But this bill would allow them to do that, according to what the language is. Further, the next paragraph talks about the direction of their care. Under the direction of a physician or surgeon licensed by the medical board or the osteopathic board, this direction shall be provided by verbal or written order by the directing physician and surgeon or osteopath, or by athletic training treatment plans and protocols that have already been established. So something could be written out last year by a physician and agreed upon with the athletic trainer that the athletic trainer is going to follow, whether the patient's seen a physician or not, has any diagnosis by a physician, which is currently being required for us within 45 days. So I have concerns.
And before all that, the athletic trainer has to determine what's wrong with the patient in order to figure out what protocol to follow. So, how are we expecting the athletic trainer's education to provide them with the knowledge on how to diagnose the patient to determine what protocol to follow? So there's a lot. I keep coming back to just the overly broad, but the language in there doesn't match our understanding of the education and training of an athletic trainer.
So I believe this is probably the 5th time that I've viewed legislative language like this. And that has always been the concern in the past, is that the Practice Act that they're proposing is overly broad. To the extent that it was vetoed twice by the existing sitting governor, who thought that title protection was more appropriate. But kind of going back to what we were discussing earlier, it's very early in the session. And when I said that there was one bill I was okay with putting a position on, given how early it is, because it was fixing something, this bill, if history says anything, this bill will also change quite a bit over the period of this session.
Similar bills, as you said, were vetoed by Governor Brown, but one was also vetoed by Governor Schwarzenegger when he was in office. And there have been a couple of other iterations that never made it out of committees with the legislature.
Any further board comment?
I just want to call attention to one other aspect that's included in the bill, which would allow an athletic trainer who's licensed in another state, another jurisdiction, to be able to come into California and practice as an athletic trainer here without having any review of their license or their certification by the California Athletic Training Committee. This board does not allow that for physical therapists to come into the state to practice without a license.
Without a California license or without a license?
Without a California license.
Actually, you have an exemption in your Practice Act to allow sports teams to come into California, or even a dance troupe, if you will, and bring a physical therapist with them from another jurisdiction. That practitioner from the other jurisdiction can only provide physical therapy services to members of that team or troupe, but there is an exemption in your Practice Act to allow for that.
Are they required to register with the board? No. Okay. Thank you.
It is an exemption to licensure.
Thank you.
And very specific.
It is very specific.
Yeah. Any public comment? Any board member feel the need to make a motion on this, on a position?
I wouldn't necessarily say take a position on it at this time, but it is riddled with public protection issues. So I don't think we need to do anything but just watch it and see how it unfolds.
So you do have an official position of watch.
Okay.
And watch does not necessitate staff drafting a letter of any kind. It's just, it will be recorded in the minutes that you took an official position of watch.
Thank you.
Thank you, Stacy.
Thank you.
If anyone would like to make a motion to change our position?
I make a motion that we take the official position of watch.
I'll second that.
Motion made by Ms. Watkins and second by Dr. Dominguez. Any further? Oh, sorry. Motion made by Ms. McMillan. And second by Dr. Dominguez. And any further board comment or discussion, and any public comment or discussion? Roll call vote.
Alicia Benayoun,
Aye.
TJ Watkins,
Aye.
Deborah Alviso,
Aye.
Jesus Dominguez,
Aye.
Daniel Drummer,
Aye.
Katarina Ellaby,
Aye.
Tanya McMillian,
Aye.
7-0. Motion carried.
Okay, thank you, Brooke. I've had a request to take a short recess for 10 minutes.
Okay.
So it's 2:11. Let's come back at 20 after.
Disciplinary. And present to the board items on the rulemaking form from the 2018 rulemaking calendar, and we're still researching these items, and hopefully we'll be presenting language for board consideration at upcoming meetings.
Okay, any board discussion on any of the rulemaking items? And any public comment?
Hi, good afternoon. So my name is Michael Skates, PT 27031. So I am been a licensed physical therapist in the state of California since February of 2002. I also have had the privilege and the honor of being a expert consultant and practice monitor for the Physical Therapy Board of California since 2008. In 2011, I participated in the revision of the California license examination for physical therapists and physical therapist assistants. I've been practicing in various environments since 2002, including teaching in a lot of different environments for physical therapists, including University of California, San Francisco, as well as Samuel Merritt College. I've also had the opportunity to develop a curriculum for a few physical therapist assistant programs and going through the process through CAPTE, so the Commission on Accreditation in Physical Therapy Education. I was contacted a few months ago by Stacy Orozco, who sits here next to me. She is the owner and operator of Contra Costa Medical Career College. The school was established in 2007, and it offers a variety of allied health programs. So Mrs. Orozco reached out to me to express her frustrations with the process in terms of offering a physical therapist assistant program. Currently, the process is regulated through CAPTE, and currently CAPTE has a backlog of about 2 years where they won't even look at your application until 2020. So Mrs. Orozco asked me to look at her curriculum independently to see if it meets the standards of equivalency so that she might be able to begin matriculating students in her school. So I did take on that task, and there were 3 different documents that I cross-referenced to see if Mrs. Orozco's curriculum met the standards that were equivalent to those of CAPTE. So the first document that I looked at was the Physical Therapy Board of California's PTA equivalency checklist. The second document that I looked at was from the Federation of State Boards in Physical Therapy, and I looked at their CWT PTA 2 form, which is utilized for the foreign trained physical therapist assistants. And then the last documents that I looked at were the actual CAPTE standards. So Standard 7 in CAPTE is what discusses the curriculum. So I looked at Standard 7A through 7D31, which basically outlines what the instructional requirements of CAPTE are. So based on looking at all 3 of those documents, what I've come up and discovered was that the curriculum meets the standards of all 3 of those documents. And what we are asking, because of the backlog with CAPTE and because of the need of physical therapist assistant programs in the state of California, particularly in Northern California, what we're asking the board to do is to exercise its authority to approve this physical therapist assistant program so that we can begin matriculating students at this institution. I would also like to add that Mrs. Orozco, she provided the PT Board of California documentation back in September of 2017 for review. And that documentation did arrive here, and we feel that it was sufficient to provide proof that she actually has met all the standards of CAPTE in terms of their curriculum.
Thank you, Mr. Skates. Just a point of order, though. I just want to note that this particular discussion doesn't have anything to do with the rulemaking calendar. Probably should be brought up during public comment, but having said that, this far into it, I'd leave it to the board to decide whether or not we want to continue to have this conversation, taking this point of order out of order and being done with the rulemaking calendar, but I'd leave that to the board. Just a point of order.
So
A
my
question.
apologies for that.
Not a problem.
A question I have is what agenda item would this correlate to? This is not, is this agendized
It
at
is
all?
not.
Okay,
So it
so,
would just be items not on the agenda.
okay.
Wouldn't be able to engage, is my point, but.
Mhm, exactly. So this is more appropriately for public items not on the agenda.
Correct.
But I mean, it's fine, the comments have been made, so you can make the comments now, but I just do want to advise the board that this is not an agendized item, so there can't be discussion on it.
So again, my apologies for that. I thought 11D was consistent with the issue that we were bringing up today. So my apologies for confusing that.
So
Actually, I'm just trying to make it fit in my mind, but it's very specific to the equivalent degree.
Well, the equivalency, again, the tool that I utilized to determine the equivalency was the coursework tool.
Yeah, no, I understand that completely. Topically, the intent of that particular item is a specific conversation that this board's been engaged in the past.
Okay.
So, but, and I'm trying to make it fit. It doesn't quite fit, but.
Mr. Skates, had you contacted the board to have this item put onto an agenda so that it could be discussed?
Directly, no, sir.
Okay.
But to be fair, we did receive the request and we have had it in review. And currently it's been discussed amongst the president and council. It is something that we're still looking at. There may be a disagreement in the interpretation of the authority within our statutes to be able to do it, and that's why it's with council now.
Okay.
Thank you for coming and presenting the information you have
Okay.
to us.
So in the future, is there a process in terms of getting a specific agenda item onto the?
You actually kind of just did it. So now, having had the presentation, the board can choose to take this on as an agenda item at future meetings.
Got it. Okay. Well, thank you for your time. I appreciate it.
Thank you.
Thank you.
Thank you for coming.
And congratulations on earning those CEUs.
Okay. So regarding the rulemaking items, any other board discussion again? And any further public comment on rulemaking items?
Okay, and the last item underneath the rulemaking report is the disciplinary guidelines, and I'll go ahead and defer to Elsa.
So as indicated by Brooke, at the November meeting, the disciplinary guidelines were approved by the board and staff was directed to go ahead and proceed with the rulemaking file. However, there's two more sections that I would like to bring to your attention for some revisions on the language. And the first one is the definition of substance abuse rehabilitation programs. And that language has been amended to delete the reference of a diversion program since it no longer exists in our current statutes. And then the second one, I know there was a lengthy conversation regarding Business and Professions Code 480 that was added to the guidelines. However, it was very specific to convictions only for the denial of the application or licensure. And since we're going through the process of cleaning up the guidelines, I recommend that we include all and any kind of violations for Section 480 and not exclusive to convictions. So the first one, for the definition of substance abuse, it's in the first paragraph, and it's basically just cleaning up that paragraph to delete diversion. Does everybody have a copy of?
Do we have a handout on that? Is it in here?
It wasn't in the agenda book itself, but it should have been just inserted as a handout. That one.
In the book.
And for people using, and for everyone using the electronic copy as I was, if you go on the board's website, there is an updated electronic
It's
copy.
included in there.
Yeah. So what you were emailed may not have been updated, but what's on the website is updated.
Does everybody have a copy?
I'll just look under yours. Yeah, I'll just look under yours. I don't know what Okay.
So for the first one, as I stated, it's in the first paragraph, and we're basically just cleaning up that paragraph to delete diversion program. I'll give you a chance to read it.
Just that first paragraph there.
That's it.
So the first sentence,
Mm-hmm.
the board does not consider licensees who have been ordered to participate in the board substance abuse rehabilitation program in as diversion?
We took,
As diversion? Is that what it's to read?
kind of yes and no. What we're saying is that we don't consider participation in the substance abuse rehabilitation program as diversion. So it would read, the board does not consider licensees who have been ordered to participate in the board's substance abuse rehabilitation programs in parentheses, as diversion.
But it's referring to licensees.
Because you can only be a licensee if you're going to participate in the board's Maximus program, the substance abuse program.
So it's just a little grammatic thing for me. It's like, it's either the licensees are in diversion or the substance program is that you don't consider the substance program as a diversion. It's one or the other. I like the concept, it's fine.
Mm-hmm.
Which of your two options is it supposed to be? That's what I'm struggling with.
I think it's whether they need to name it as licensees or whether it's that our substance abuse rehabilitation program is not diversion.
Mm-hmm.
Okay.
If that's more important than
So
the board's substance abusing rehabilitation program is not considered diversion.
So I think it's a question of intent. What's the intent of that sentence? Is it to point out that the program, the substance abuse program, is not diversion?
Yes.
Okay. Then I think that option of taking out licensees and saying the board does not consider the substance abuse rehabilitation program to be diversion, something like that.
to be or as diversion, or which one do you prefer?
Away from discipline, like a way to not face discipline. The question was, what is diversion?
Yes.
How about the board? The board's substance abuse rehabilitation program is not considered diversion.
Simple.
Is that close?
Simple.
And given the way the sentence is structured now, I've been quiet because I'm struggling between the two and the idea of the intent, as Sawa mentioned, and the reason I was struggling is because we even use licensees in that sentence. It's difficult to say, is it about them or is it about the program itself? I think the way you stated it is much clearer and more concise to address either of the intents. It's very clear that whoever is looking at that is going to understand. And I'd even go one step further to say diversion from discipline, just for clarity.
Yeah, the way you just said it was perfect. And then the following sentence takes it a step further, where it says, as a result, the board will not use the term diversion in these guidelines.
Mm-hmm.
So that just solidifies it, in my opinion.
So is the board fine with that? Any public comment? Okay.
Can the sentence be repeated, please?
Yes, thank you.
Did you get that, Brooke?
I believe so. The board does not consider the board's substance abuse rehabilitation program as diversion from discipline.
Didn't you end it at diversion, Deborah?
And
Jason
Jason
added.
added.
I think she said the board's substance abuse rehabilitation program is not considered as diversion. Is that what you said? I think that's what you said.
I love this part. I'm going to. Ready? The board does not consider the substance abuse rehabilitation program, rehab program, as a diversion. And whether you want to add from discipline or not. Thank you.
Okay, everybody got it? Okay.
Okay. We'll do the votes after, or?
Mhm.
Okay. So the second part is Business and Professions Code, Section 480, which was added to the guidelines. And again, in November, it was adopted to include 480. However, it was inclusive to convictions. So I worked with Salwa on this, and we've added 480 for any kind of violation.
What page is this in the agenda book?
It's not in the agenda
It's
book,
not?
it was the handout,
Okay.
the memo.
So 480.
It's the grounds for denial of applications for licensure.
All of those are new inserts.
What the board originally looked at the last meeting was just the top one, essentially, 480A1. But when it was discussed, it wasn't entirely clear that we were just talking about 480A1. We talked about 480 generally, and it was when staff and myself went and looked at it later, and we said, oh, you know, it's probably better to make it more clear that we're not just talking about, you know, what the board had passed before, which was this, okay, if there's an issue with 480, look at 490. Well, that doesn't apply to the other subdivisions, 480A2, A3, and 480D, because 490 just has to do with convictions. So what we did was we went back and said, okay, the board had passed the first section, 480, but only having to do with 480A1 convictions. So we broke it down and said, okay, let's do it for each subdivision to give guidance. And that's because the subdivisions of 480 are just so different. That's why we thought they needed their own section, because 480A1 is convictions, 480A2 is denial of application of licensure relating to dishonesty, fraud, deceit. A3 has to do with denial of licensure for any act done by a licentiate. And then 480D is denial of application for licensure, false statement of fact for application. So they really would have kind of their own separate conditions that wouldn't be the same as 490. And that's why we broke it down this way.
Can you please provide some clarification on 480A3? And what does done any act if done by a licentiate? What does that mean? What does that include?
So this one is kind of like the 2660 unprofessional conduct, where there could be a lot of different things that would fall under 480A3. So that's why at the bottom it says refer to the corresponding statute for conditions of probation. So if, you know, a licentiate violates something in the act, then an applicant can have if an applicant does the same thing, they can have their application denied for that. And if the board were going to enter into a step, they'd have to determine probation conditions. And we thought, well, how do you do that? Well, just refer to the statute that the applicant violated that would have been a violation for a licentiate, and then use those conditions.
Thank you.
That wording is just a little tricky, huh?
Mysterious, yeah.
Done any act if done by a licentiate.
I think we pulled that.
Yeah, that's
The
a-
titles, yeah.
It's called.
That's from
Yeah.
statute.
Mhm.
The peculiar part of this language, which sometimes makes it difficult to address, is the disciplinary guidelines were originally drafted with licensees in mind, right? While we use them as a guide to also and apply to a denial and somebody who's entering into a stipulation, the document itself has always been authored with the intent of licensees, right? But I think there's a value in including this language in there to make that bridge so that even applicants who might have some of this history could have a foreknowledge in what they might be coming up against or what the board might do in certain circumstances. So they always could have done that before, but I think this provides them that they're in the right place, right? They read 480, they see that this is the bridge, that these things could also apply to me. This is where I should be. Either they or their legal counsel or what have you. There is some, throughout the whole document, there is going to be this kind of quirky inconsistency, though, because the intent of this document was for the Practice Act violation of a licensee or anything substantially related to. And now we're kind of adding to it the application process of future licensing.
Mhm. Yep. Any further board discussion, comment? Any public comment?
I'll refer to Salwa to look at the action requested to see if that motion is appropriate.
Thank you. I think it's a good motion. I would just recommend adding some language to it. In the last sentence where it says, "and if no hearing is requested, adopt the proposed regulatory changes as modified," I would recommend adding language there that says, "and if no adverse comments are received during the 485-day comment period, and if no hearing is requested, adopt the proposed regulatory changes as modified." Does that make sense, or should I read the motion together?
Would you mind reading the whole thing for us? Thank you.
Okay. I move we approve the proposed modified text presented today and incorporate these changes to the existing rulemaking packet approved at the November 2017 board meeting. Direct the executive officer to take all steps necessary to initiate the rulemaking process. Authorize the executive officer to make any technical or non-substantive changes to the rulemaking package. Notice the proposed text for a 45-day comment period, and if no adverse comments are received during the 45-day comment period, and if no hearing is requested, adopt the proposed regulatory changes as modified.
I would suggest just one other addition in the first line, that we approve the proposed modified text as presented and amended today, so that we capture the changes proposed by Dr. Elvey, presented so succinctly by Dr. Elvey. So.
So moved.
I'm sorry, you're going to have to read that motion.
Without looking, yeah, from memory. Second.
We have a motion by Ms. Ellaby and a second by Ms. McMillian. Any further board comment?
Procedural question. Do we not have to have hearings?
We do not. This board has typically, well, for as long as I've ever been with the PTBC, have had a hearing with every regulatory package that we have. And it's not to say that we won't do it with this one. What I would ask the board to consider, though, is there is now a new review process that creates a very lengthy period of time, if you will, before a regulation can become effective. If there are no adverse actions, it's completely within the right to do it without a hearing. And I think in that regard, it's completely appropriate. It would also allow us to effectuate that language much quicker. We wouldn't have to worry about scheduling a hearing to coincide with a board meeting or ask for an emergency board meeting to account for it or anything like that.
So a hearing would be used more if
if we received any adverse comments.
Or if someone requested a
Correct.
hearing.
Right.
Somebody requested it, or if in this board's thought that it was something that needed the opportunity.
Right, absolutely.
Okay. But it's more for those reasons than that you must have one.
Correct.
Okay.
Any further board discussion?
I will just say one thing to that. In those circumstances where the regulation may have any amount of controversy attached to it, I would always encourage this board to have the hearing. In these kind of slight amendments or something that's some cleanup, if you will, where it's not really that point of controversy, we're still allowing the public to provide that information and have that potential hearing need be. But again, with that new review process, we might have to consider that no hearing possibility for some of these to get them through. But again, when it's appropriate.
How's that, Dr. Alviso? Any public comment? Okay, roll call vote.
Alicia Benaimon.
Aye.
TJ Watkins.
Aye.
Deborah Alviso.
Yes.
Jesus Dominguez.
Aye.
Daniel Drummer.
Aye.
Katarina Ellaby.
Aye.
Tanya McMillian.
Aye.
Motion carried, 7-0.
Thank you, Elsa. Brooke, anything else in rulemaking today?
No, I'm finished. Thank you.
So at this point, we have pretty much finished up on day one.
We have, and considering what the amount of business we have for tomorrow, I think that's okay. I'm not worried or pressed for time. I don't think that it's necessary that we move anything, and having to worry about people and access and that kind of thing. I think we're good.
And any further public comment on items not on the agenda that anyone would like to bring forward? Any questions that anyone has? You're welcome to come forward. Not today? Okay, so we'll go into recess. It's 2:55 and we'll reconvene tomorrow morning at 9 a.m.